Another update in the Kelsey Fitzsimmons case. And before we get to the update, I just want you all to mark your calendars that for October 7th, that is the next hearing in Kelsey Fitzsimmons' case. So we will definitely be covering as much as we can of that case and see what happens, see if she is able to get released from jail. And we'll talk about that in just one moment. But just mark your calendars. October 7th is the next date. I don't know exactly what time, but I'm sure it'll come out. So Kelsey Fitzsimmons, very briefly, was shot in the chest. That's what led up to all of this. The reason she was shot in the chest and she actually made a recovery from that is that some police officers showed up at her house to take away her baby. And she was not very thrilled about this. And the question is, what did she do? According to the police who responded, she pointed the gun at them. And therefore, one of them, Officer Noonan, shot her. Now, she did live to tell the story. She went to the hospital. She's in the hospital for over 50 days, something like 53 days. And she suffered some very serious injuries, as you can imagine, by being shot in the chest by a bullet. Now, she herself is a police officer, and at some points she had some issues with postpartum depression, and maybe they took away her gun, put her on leave. But the preferential treatment that normally police officers get, she's not getting any of that. And the question here is, okay, so she was arrested because, maybe she was attempting to murder these police officers, although the grand jury did not indict her on attempted murder. They only indicted her on assault with a dangerous weapon. Okay, so she was arrested either way, and she was arraigned from the hospital bed, and eventually she was granted bond. So she was out, she was on house arrest, and she had to also, one of her release conditions was that she blow into this scram device to test her for alcohol. You have to make sure that she's alcohol free after all. And the question is why? Well, okay, we don't have to get into that because a lot of times you're going to have to just be alcohol free regardless of what the crime is. So she has to blow into this scram device, which is very difficult for her because she has these broken ribs and other types of injuries that are associated with being shot in the chest. Very understandable why someone can have trouble breathing into a machine for extended periods of time with a certain force. So after just a couple of days of having this machine, her attorney did file a motion to modify her release conditions. That's all he did. He asked, and this wasn't a proceeding that was initiated by the probation department saying that she's not being compliant with her release conditions. That's not what happened here. Bradel, her attorney, who's also representing Turtle Boy, by the way. So her attorney, Timothy Bradel, filed this motion just asking the judge, can we modify these release conditions? Have some other way, alternative measures, alternative way for her to test so that she doesn't have to go through this torture of breathing into the scram device. That's all he was asking for. And as a result of that motion hearing, the judge decided to lock her up. Okay, so there's a lot of problems with that. The first problem, most obviously, is that under the statute, which we discussed in our last video, under the statute, the only time a judge is allowed to change the bond conditions or revoke bond is if there has either been a violation of a law, you committed another crime while out on bond, okay, then you got to go back into the slammer. But there's another way, is that if you violated your release conditions. Well, did Kelsey violate her release conditions? And it's very clearly that she did not. The probation office did not initiate these proceedings because she violated it. And in fact, the probation officer himself said in the hearing that he would not consider what she did a violation because after all, even though she did not get a reading, it was an incomplete test at certain times of the day, but she did eventually complete the testing. And they would not consider this a violation. So nobody here is considering this a violation. And the judge, nevertheless, even though the law requires her to find some sort of violation, decided to revoke her bond. So that, number one, is obviously just at odds with the statute. So there was no basis for her to do it. So Bradel then filed a motion for reconsideration. So this is just, his first motion was just to change, to modify the release conditions, that she should be able to test in some other easier way, like urine. Very simple, easy way without having to breathe. And someone who has broken ribs and other issues with being shot in the chest, like bullet fragments and things like that. So it's very difficult for her to breathe. So just do a urine test. It's very simple. And therefore he filed this motion for reconsideration. Now, one of the issues that the judge had with the initial hearing, his initial motion, was that he didn't attach any medical evidence, because even though it's a non-disputed point that she was shot in the chest, and it's very intuitive and reasonable for anybody to understand, anybody with any sort of life experience to understand that someone has broken ribs is hard. It's hard for them to breathe. Still, the judge wanted medical evidence. And it's not enough that there was observations by the probation officer who was happy to testify about it that she did have trouble breathing. That wasn't enough for the judge. And in fact, she also said, well, anyway, the affidavits are hearsay and the email is hearsay. There's an email from the probation officer, and that's also hearsay. So I can't consider that. In fact, she said that she gives that 0 weight. And we're going to see also, which we showed previously, that that's also at odds with the statute. The statute says that at these type of hearings, you don't need to follow the rules of evidence in a criminal trial. For these type of hearings, for revocation hearings, you could even rely on hearsay. So that was, again, another mistake that the judge made. So Timothy Bradel filed a motion for reconsideration, which we went through yesterday in the video. And now we have a supplemental filing to the motion for reconsideration. So let's pull it up. Let's go through it, and let's talk about it. Here we go. Defendant's supplemental exhibit filing on her pending reconsideration motion. Now comes the defendant, Kelsey Fitzsimmons, and respectfully files the attached doctor's letter from Jonathan Parks, MD, the trauma surgeon that attended to Ms. Fitzsimmons during her stay at Massachusetts General Hospital. In the hearing that preceded the pending reconsideration motion, the court expressed its concerns that it desired medical evidence relative to Ms. Fitzsimmons' condition. Give me a second here. And on the assertion that her broken ribs could impede the deep breathing necessary for the scram device, causing pain and trauma to the defendant. The defense has obtained a letter from her surgeon addressing these concerns and corroborating Ms. Fitzsimmons and her mother's previously filed affidavits, and files a true and accurate copy herewith. There is no request for impoundment, which is why we get to see it and show it to you. Wherefore, the defendant requested an alternative means of alcohol testing be implemented, such as urine testing at Ever Health Systems, a Commonwealth vendor, 10 minutes from defendant's family residence, and that the defendant be returned to her previously allowed terms of release. Now, look at the footnote here. You know how much I love footnotes, and I hope you can read it on the screen. The Supreme Judicial Court has always allowed the use of hearsay at probation revocation hearings. So remember, I showed this to you straight out in the statute. Well, there's also, of course, going to be case law that also agrees with this. And that's what they're showing from this case. Commonwealth versus Drilling. See also Commonwealth versus Calvo. Unavailability of witness not required to be shown for admissibility of reliable hearsay. The revocation process should be flexible enough to consider evidence, including letters, affidavits, and other material that would not be admissible in an adversary criminal trial. Similarly, the Supreme Court has sanctioned the use, where appropriate, of the conventional substitutes for live testimony, including affidavits, depositions, and documentary evidence. So what would this letter from the doctor be? It would be considered hearsay. That's right. It would be hearsay, but guess what? It's okay, because the law is clear in Massachusetts that for revocation hearings, you are allowed to rely on hearsay. So this is put in the footnote. Some people would argue that you should put it in the body of the motion, because this is exactly where the judge got it wrong. One of the errors that the judge made that was clear. And again, on top of that was the major error, which is that there is no basis to revoke her bond because there was no violation. Nobody here considered this a violation. The probation officer did not consider this a violation, and nobody found it. The judge just preemptively decided that she's not going to comply without any violation. Okay, anyway. So let's take a look at the letter from the doctor. Now, we have to understand just how hospitals work. I'm sure a lot of you do, but when someone goes to the hospital, so a lot of times you first see the registration, and then you see a nurse, and then you get vitals taken, and then maybe get some blood taken, and then maybe the ER physician will see you, or the resident will see you first, and then maybe the attending ER physician will see you, and then eventually it works its way up the chain of command, and then you eventually get to someone like a trauma surgeon who needs to be called down at that time to do an emergency surgery. So Jonathan Parks, that's who this letter is from, as you see from the top right over here. Jonathan Parks, just a very quick look at what he does. So he's a fellowship program director. He's also surgical critical care, trauma, and acute care surgery. And we have the clinical instructor in surgery at Harvard Medical School. So probably not an easy job to get, to be the clinical instructor of surgery at Harvard Medical School. So this is, a pretty well-acclaimed surgeon. It's not just that they went for the ER physician, which also would have been adequate, or the resident, or the the attending physician, or any nurse. They went to the top. They went to the actual surgeon. All right. To the Honorable Court, dated September 15th. I was the trauma surgeon on call when Ms. Fitzsimmons was admitted to Massachusetts General Hospital with multiple gunshot-related injuries. Her documented injuries included gunshot wound to the right hemothorax with retained bullet fragments in the right upper back, moderate right hemothorax requiring chest tube placement, right middle and lower lobe pulmonary contusions with active bleeding, grade 4 hepatic trauma with active bleeding from the right hepatic lobe, comminuted right posterior 12th rib fracture, and right anterior 11th rib fracture at the costochondral junction. Her treatment course included multiple procedures, including chest tube placement, percutaneous drainage of a hepatic collection, and ERCP with biliary stent placement. So basically, a short way of saying, yeah, she was really messed up as a result of being shot in the chest. All these issues, chest tube placement, contusions, active bleeding, rib fractures. Okay. In my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement such as deep breathing. So here you have a medical opinion saying that yes, these retained bullet fragments as well as a 12th rib fracture can cause pain, which can persist for several months after the injury. And even though, again, he hasn't evaluated her or treated her in the past, since the hospital, it looks like, this is what he's giving his opinion about. So if the judge really wants to nitpick, the judge can say, well, this doctor hasn't seen her recently. He's not giving an opinion that she actively does have these issues breathing. He's just saying that it's possible that she does. And that's not good enough for me. So that may be what we hear from the judge next. And I wouldn't be too surprised. But at least they went to the doctor, went to the top, and you see all the issues that she had. And at this point, it should just be, again, intuitive that she's got obviously issues breathing into the machine. And this is not an attempt at doing anything. She doesn't want to do anything nefarious. She just wants to be able to test in a different way. Do a urine test. It's that simple, judge. Let her do a urine test. Or if you don't let her do a urine test, well, then let her go back to the scram machine. Okay, and then release her. And she'll go through that torture, and that'll be fine. She's happy to do that, rather than staying in jail. So that is exactly what should happen here, and we'll see what the judge does with this motion for reconsideration. Alternatively, I hear that Timothy Radel may be also filing an appeal or getting ready to file an appeal and appeal this specific issue. So that is what is the news with Kelsey Fitzsimmons. That's the update. Again, we have the hearing coming up October 7th, and we'll see if anything happens up until then. If it does, obviously we'll report on it and do some research and give you some of the legal analysis on whatever's going on with Kelsey Fitzsimmons. Because unfortunately, what happened, again, is sickening. She does not belong in jail. She belongs released and just doing urine tests. All right. Well, that's going to be it for now, and we'll continue to follow the case. If you haven't yet, please subscribe and like, and we will see you next time.